in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Welcome. Today is Judge Aaron Gauthier. Another good judge. I don't know what to say except welcome. Welcome all the new subscribers to this channel. Thank you for your support. And if you like this kind of content and you're not a subscriber to this channel, please do me a big, huge favor and subscribe to this channel and help this channel grow. I really appreciate your support. Any support that I can get from you I'm grateful for. So let's get started with Judge Gauthier. I'll make this bigger. Okay, I'm going to be here, but I will be in the background with the mic muted. So here we go.
Got people the Nicholas Misiak up for an arraignment, file 25-93-386FH. All right, and I have a plea agreement in front of me as well. For purposes of arraignment, do you and your client waive the reading of the allegation?
We do, Your Honor. We have received a copy of the information and we believe it's reading.
And is a forensic center referral requested?
No, Your Honor.
All right. All right, Mr. Misiak, would you please raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Put your hand down. Are you Nicholas Jean Misiak?
Yes.
Mr. Misiak, a guilty plea hearing is an important hearing because you waive rights that you have. So I want you to listen very carefully. If you have any questions for me, go ahead and ask. I'm happy to answer them. If you need more time to talk to your lawyer, you just go ahead and say so. Do you understand that?
I understand that.
Now I have to advise you the maximum penalty for the charge in count 1 of stalking a minor is a felony punishable by a maximum of 5 years in prison and or a $10,000 fine and up to 5 years of probation. Do you understand that maximum penalty?
Yes, sir.
Are you on probation or parole anywhere else?
No,
Were you on bond for any other case at the time of this incident?
No.
Did you read and understand the rights listed on the advice of rights form?
yes, Your
And
Honor.
you signed that?
Yes, sir.
Do you understand that that lists the rights that you would have to a trial?
Yes, Your Honor.
And that if you plead guilty, you won't have that trial?
Yes, Your Honor.
Therefore, you give up all those rights?
Yes.
And is that what you choose to do today?
Yes, Your Honor.
If I accept your plea, you also give up any claim that it was caused by any promises beyond the plea agreement or any threats. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you give up the right to appeal. And if you wanted to appeal, you'd have to seek permission to do so. You would do that by filing an application. Do you understand that?
Yes, Your Honor.
Now, but when you plead guilty, the types of issues you could raise on any appeal are very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes, Your Honor.
All right, the plea agreement provides an exchange for your plea of guilty to that charge. There's a sentence agreement that you'd be placed on a statutory delay of sentence for a year. And during that delay, you'd be subject to different probationary terms. If you completed the delay, then the charge would be reduced to misdemeanor stalking with no jail on that charge. And also that this would be a non-SORA case. Do you understand that?
Yes, Your Honor.
Mr. Boyd, is that a full, fair, and accurate statement of the terms of the agreement?
It is, Your Honor.
Mr. McLennan?
Yes.
All right, Mr. Misiak, that sentence agreement is not binding on me. Meaning if I didn't want to follow it I don't know anything about this case. I don't know anything about you. At the time of sentencing, I'll know more. And if at that point I decide I can't live with this, then I don't have to. But if I don't follow this agreement, you would be allowed to withdraw your plea because you wouldn't be receiving what you bargained for. Do you understand that?
Yes.
There is a very important exception to that rule. Here's what it is. If you engage in any misconduct between now and the sentencing, by absconding on your bond, missing a court date, violating bond, committing a new crime, anything like that, then by your own misconduct, you would lose the right to withdraw the plea, even if I didn't follow that agreement. Do you understand?
Yes, Your
It
Honor.
means you do fine, you show up to court and I follow this, you're on a delay of sentence, no jail, and a misdemeanor at the end if you behave. If you misbehave between now and the sentencing, you show up, I could revoke it and send you to prison. You get that?
I get that. Yes.
Other than the plea agreement, has anybody promised you anything to get you to enter this plea?
Not at all.
Has anybody threatened you to make you?
No.
Is it your own free choice to enter the plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 1, stalking a minor?
Guilty.
Mr. Boyd, would you assist with the factual basis? Please?
Yes, Your Honor. Thank you. Mr. Mishak, in June of 2025, were you acquainted with a person with the initials of KW?
Yes.
And did the two of you engage in a series of communications during that time?
Yes.
And were you in Presque County at all relevant times during those communications?
Yes.
Was the communication initially a mutually interested communication?
Yes.
And as we stand here today, are you now aware that KW was a minor at all relevant times?
Yes.
Okay. Did there come a time when KW told you to stop contacting her?
Yes.
And despite that, did you continue to communicate with her after she told you not to?
Yes.
Okay. Would you agree that she felt harassed by that communication?
Yes.
And would you further agree that a reasonable person might feel harassed by communication after being told to stop communication?
Yes.
And at all relevant times, were you 5 years or more older than her?
Yes.
Judge, I think that's a sufficient factual basis.
All right, you agree, Mr. McLennan?
I agree, Your
And
Honor.
Mr. Voida, you're aware of any other promises, threats, or releasements?
No, Your Honor.
Mr. McLennan?
No, Your Honor.
And Mr. Voida? In your judgment, has the court fully complied with the requirements of MCR 6.302?
I believe you have, Your Honor.
Mr. McLennan?
Yes, Your Honor.
Mr. Mishak, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I hereby accept your plea. We'll schedule sentencing for March 16 at 10 a.m. Before you leave, you stop in to check in with probation agent here and get her card so that you can make an appointment for a pre-sentence report. You'll have to do an interview so I can learn more about you before the sentencing. And Mr. McLennan, any objection to continuation fine?
No objection.
Will be continued.
Thank you.
Is that all you have today, Mr.?
That's all.
All
Thank you.
right, you have a great day.
You too.
Get somebody on Zoom. Let me see who this is.
Sorry.
Good morning, sir. Can you tell me what your name is?
Brian, Pe-
Brian Fields? Okay, let me bring in your attorney. All right, good morning. Up next, we've got an arraignment in two files. People be Brian Fields. It's files 25-93388FH and 93389FH. Counsel, you want to state your appearances beginning with people?
Jeremiah Buffalo, work on behalf of the people.
Thomas Seeger appearing with and on behalf of Mr. Fields.
Mr. Seeger, I see you're in a car. You're not operating a moving vehicle right now, are you?
I am not, Your Honor. I am clear. Yes, I am parked. Yes, Your Honor.
Have you had a chance to review the charging clients in both files with your client?
I have, Your Honor. He would waive further reading.
Has he wished to plead to those charges?
He would plead not guilty, Your Honor.
Okay, we'll enter pleas of not guilty in 93388 to conducting criminal enterprise. Looks like 2 counts. Receiving and concealing over 20,000, 2 counts. Larceny over 20,000, 2 counts. And a conspiracy larceny 20,000. And in 93389, charge of delivery methamphetamine, computer crime, and habitual notice. It's a forensic center referral requested.
It is not, Your Honor.
Estimated length of the trial in each matter.
Your Honor, I would suspect that the delivery case would probably be a day and a half, and I would suspect that the alleged racketeering case would probably be maybe 2 days.
Docket call appropriate for March 16th at 10:10 a.m.
That would be fine, Your Honor. I guess the only thing that I would ask the court to consider doing, and I'm not familiar with your mechanisms, is I don't practice in Presque Isle regularly, nor do I practice in the other county that you are the judge in. But I was just served with some discovery recently. I have to review that. There are 2 files, and the one case is probably more complicated than the other. I did discuss with the prosecuting attorney some motions that I may file, but he was gracious and said that perhaps we can discuss them in advance of filing. So if we're able to come to a resolution, that's very helpful. If we're not, then I would have to file the motions. Either which way, Your Honor, if the court was willing to give us a docket call in maybe April instead of March, and I'm not sure, Your Honor, if you're there once a month or twice a month, what have you, but a later date might be helpful just in terms of potentially trying to determine if we can resolve certain issues, and if not, then we can go forward with those issues.
Where's your principal place of business, Mr. Seeger?
Traverse City, Your Honor.
Okay. Any objection to the Zoom appearance at the docket call?
None at all, Your Honor.
Okay, what I'll do, Mr. Seeger, is I'll leave it on the March 16th date. Just that's about 6 weeks out, just so that we can touch base and see where we're at. Experience has taught me if I set something too far out, no matter how far we set it out, when we're here, I might yet hear from the lawyers, oh, something fell off the radar and we need to do something. So I'd rather find that out sooner than later. So we'll leave it on March 16th at 10 a.m., but I will authorize you and your client to appear by Zoom video as you have here today.
Thank you, Your Honor. Your Honor, I would note that in speaking with the prosecuting attorney, he was very gracious in terms of potential bond amendments, or at this time, employment has not materialized in the way that we had discussed. To the extent that something comes up wherein employment is available, either we would submit a stipulated order or a motion of some sort would be filed.
Okay, very good. And at the docket call, if you have any motions you want to notice up for the same date and time that are non-evidentiary motions, don't require testimony, you can just do so. If you file a motion that needs some testimony, contact my assignment clerk in my Sheboygan chambers, and they will schedule a date and time for you.
Thank you, Your Honor. Just for my own clarification, do I need to, if there are motions that are filed, do I need to create the notice itself, or is that something that the court
Yes.
generates?
No, you would need to notice them up, yeah.
Thank you, Your Honor.
All right, anything further from the people?
No, Your Honor.
Anything further from the defense?
No, sir.
Okay, you have a good day.
Thank you, Your Honor.
All right, and Mr. Gilbert, we have an agreement and people be Sarah Morris. This is file 25-93387.
I did file the waiver for Ms. Morris. I submitted it to the court this morning.
I do not.
Put it down.
Oh, you filed it while I was in here.
Well, we'll pass the case so that we can get it,
Okay,
if you want to go down and get it.
actually, I probably have a copy in the file. I can hand it to the court right now.
Okay. Jim.
No, all right. Find my approach.
All right, the waiver of arraignment being filed indicating that defendants received the information would waive its reading. Enter and stay on mute. Will enter a plea if not guilty. The R&O and child abuse, domestic violence charges. In the forensic center, is the forensic center referral requested?
It is not.
Would be the estimated length of trial.
Probably 2 days max.
Appropriate for a docket call on March 16th at 9:10 a.m.
Yes, Your Honor.
Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, thank you.
Okay, I'll hear the arraignment in next case. All right, and Mr. Vogler, that brings us next to people v. Christine Bennett, file 25-93364 FC. Miss Bennett. She's not up here. Okay, they have not zoomed in. We'll pass that case. Is the jail going to zoom in with Miss Bennett? Her case is up. All right, well, Mr. Gilbert will call people v. Lyle West. Is he present? This is file 25-9333H. Council, you want to state your appearances, beginning with people?
Zachary McLennan for the people.
And James Gilbert here on behalf of Mr. West.
All right, and we're here for a docket call. What's our status
Oh,
here?
Your Honor, we had ordered the preliminary exam transcript. I did follow up on that last week. I guess it's almost done and we should have it at any time, but we have not received that at this time.
Okay. Continue to March 16th at 9:20 then?
That'd be fine, Your Honor. Thank you.
Anything further from the people,
No, Your Honor.
from the defense?
Your Honor, would the court consider a reinstatement of Mr. West's bond? He had, it did get revoked due to some failed tests. However, Mr. West has never failed to show up for court. And he was very active in his case prior to the incarceration, and he has sat quite some time due to that violation. So
The bond it was revoked in the district court?
it was.
Okay, do you know when that was? Or?
About 2 months ago, Your Honor,
I believe it was December 9th.
December 9th.
December 9th. Mr. McLennan, what's your position?
Your Honor, Mr. West is on bond for serious felony charges. It appears drugs were part of the issue here. He wasn't charged with those types of charges, but were contributing to the issues. He used meth while on felony bond. I'd ask bond remain revoked.
I'm just reviewing the records sent up from the district court about that because it happened pre-bind over, so I wasn't familiar. Looks like it wasn't just an isolated test. It happened at least a couple times and then he missed another test. So I think at this point, without further information or a further plan for how we might prevent that in the future, I'll leave bond revoked as it is.
Thank you.
All right, Mr. Vogler, I see the jails. All right, Ms. Bennett, is that you?
Yes, sir. Christine Diana Bennett, 8853.
This is file 25-93364FH. And we're here for a docket call on Mr. Vogler. Last I knew, you were awaiting possibly an independent evaluation for criminal responsibility. Is that still the plan and what's the status?
Yeah, it is the plan, Your Honor. Our expert met with Ms. Bennett, I believe on January 20th, he came up here. And in my communication with him, since that time, we I asked him to put his report on hold to allow me an opportunity to obtain some older psychiatric records of my client. I will tell you that they may be difficult to obtain or may not exist anymore, but basically our feeling that it would give us a better psychiatric picture. Fine. That being said, I would ask the court, and whether I have to put this in the form of motion or not, regardless of how we proceed going forward on an insanity defense, I would be asking the court to stay the case pending the Michigan Supreme Court decision.
Undiminished capacity.
I see statewide that this is what's happening in various circuit courts, and people potentially want to put that defense on and don't really know whether it's going to be.
Right, well. Right, oral argument was held in October. So I mean, I expect we'll get a ruling this term. All right, Mr. McLennan, people's position.
Your Honor, I would agree with Mr. Vogler on staying the case pending the outcome of the Michigan Supreme Court case that could have an impact on.
Well, I mean, I'm not sure whether at this point we need to stay it if we are. I mean, you're still gonna want to get those records anyway.
Correct.
So I certainly appreciate you bringing it to the court's attention. It would be a possible diminished capacity defense. My thought is we don't enter any order staying it at this point. The only benefit to that seems at this point would be where I wouldn't get dinged by the state for time guidelines on the case, but I'm less concerned about that. As long as you're still needing to continue the docket call to allow you to get the records.
Correct.
So I haven't scheduled it for trial. Once we get to a point where we're ready to schedule it for trial, if at that point you want to not schedule it to await that decision further, I guess at that point, under that. Because they didn't grant leave, it was an oral argument on an application. So, I mean, I don't know what they're going to do. Sometimes at the end of that, they just deny leave.
Oh, is that what that was?
Yeah, it was an oral argument on the application. Yeah. So I don't know. So it's hard to predict what's gonna happen with that. Well, maybe you want me to put this, I've got a call at the end of March 30th. You want me to do that? Give you
That'll be
a
fine.
couple months here to try to get those records. All right, let's continue it to March 30th at 9 a.m. Anything further from the people?
No, Your Honor.
Anything further from the defense?
Oh, Your Honor.
Okay. See. All right,
Thank you,
Ms.
sir.
Bennett, you're all set today.
Thank you, sir.
All right. All right, Mr. Vogler, do we have Ms. Dockstaters here?
Yep.
Let's go ahead and do that. All right, and this is will be Alicia Dockstader. It's two files, 25-93382FH for a docket call and 24-93008FH for a probation violation from the same incident. Here. All right, and Mr. McLennan, is this your case?
This is Mr. Wirtle's case.
Mr. Virgo, do you have an amended information for the plea agreement here?
We do not, Your Honor. It would be forthcoming.
I strongly prefer them on the day of.
Yes, Your Honor.
Start doing that because I need to advise of the penalties. So tell me the penalties on your added count 5.
Your Honor, my apologies. I would have to, myself, I would.
It would be well, it's a 5-year max.
Okay. Okay, and the fine would remain the same, I think, under the tenth, right? So it's 5-year, 20,000.
And I noticed on that plea form as I was handing it to you, I think the one file number, the 93308,
Yeah,
that should be a 2024.
yes, that's right. That's right. Ms. Dockstader, would you please raise your right hand, as best you can for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can put your hand down. All right, Ms. Dockstader, a guilty plea hearing is an important event, so I want you to listen carefully. If you have a question, go ahead and ask me. If you need to talk to Mr. Vogler, you just let me know, okay? The maximum penalty in count 4, vulnerable adult abuse, it's a misdemeanor punishable by up to a year in jail and or $1,000 fine. And then added count 5, attempted unlawful imprisonment would be a felony punishable by a maximum of 5 years in prison and or a $20,000 fine. Do you understand that?
Yes, sir.
You are also on probation to me in the 24 file for domestic violence, 3rd offense. That carries a maximum penalty of 5 years in prison. Do you understand that, Max?
Yes, sir.
Did you read and understand the rights listed on the advice of rights form?
I did.
And you signed that?
I did.
Any questions from your or your lawyer about any of those rights? And do you understand if you plead guilty, you'll give up all those rights and won't have a trial?
I do.
Is that what you want to do today?
Yeah.
And you understand you've got the right to have a hearing on the probation violation with the assistance of an attorney as well?
Yes.
Okay. And do you wish to waive that hearing as well?
I do.
All right, the plea agreement provides that I'm sorry, if I accept your pleas, you give up any claim that it was caused by any promises beyond this plea agreement. And you give up any claim that it was caused by any threats. Do you understand that?
I do.
Also, when you enter a plea, in an appeal, you'd have to get permission to appeal, use the right to appeal. And you'd seek permission by filing an application. But the types of issues you could raise would be very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes, sir.
All right, the plea agreement provides that for your plea of guilty to counts 4 and the added count 5 that I outlined, and understanding that that would also constitute a violation of your probation, the prosecutor will dismiss the remaining charges. With the deadline for this, that it would expire at the March docket call. So this would remain open for a month if you didn't want to today. And there's a sentence agreement that if I were to sentence you to prison, there'd be a 13-month cap on prison time, sentence within a guideline range of 12 to 24. And that cap would apply to both files, and any sentence would run concurrent. Do you understand the terms of that plea agreement?
Yes, sir.
Mr. Vogler, is that a full, fair, and accurate statement of the terms of the agreement?
It is, Your Honor.
Mr. Wirgo?
It is, Your Honor.
Okay, counsel, if you just understand on the sentencing guidelines portion, the the parties can specify a sentence within, they can agree to a sentence within a specified range, and the sentence must be within that range. But I have an independent legal obligation, statutory obligation to score the guidelines appropriately. So how I score them might end up different from 12 to 24. I did not change the scoring to comport with a plea agreement. To stay within a plea agreement, I have to follow and keep the sentence within a specified range.
If I may, Your Honor, then with language such as the parties agree that the guideline range for effectual sentence would be, or something along that line, as opposed to the guidelines will be scored at.
I honestly don't know what purpose this sentence scores in this plea agreement where you have a cap anyway.
The cap was added later, Your Honor.
Okay. If you didn't have a cap, then it would just say sentence to be within a guideline range of whatever.
Perfect. Thank you, Your Honor.
All right, Ms. Dockstader, that sentence agreement it all boils down to, in both files, there's a cap by this agreement that doesn't mean that I have to send you to prison, but if I decide to send you to prison, then the maximum sentence, or the cap on the initial sentence would be 13 months, be 13 months to 5 years. You get credit for time you've been in. And then at the end of that 13 months minus the credit, you'd be eligible for parole. Do you understand that?
Yeah.
Now that sentence agreement is not binding on me. If I wanted to give you more than 13 months, I don't have to stick to this. But if I didn't stick to this, you could withdraw your plea because you wouldn't be getting what you bargained for. Understand that? That's unless you engage in some misconduct between now and the sentence. Say that you commit a new crime. Sometimes people do that even when they're in jail. You violate some court order, engage in serious misconduct. Then you lose the right to withdraw the plea, even if I didn't follow that agreement. Do you understand?
Yes, Your Honor.
Other than this agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 4 of vulnerable adult abuse?
Guilty.
And how do you wish to plead to what will be an added count 5, attempted unlawful imprisonment?
Guilty.
Your Honor, if we could just pause for a second.
Yeah.
And I want to talk to her a little bit about those guidelines, thing that we just went through.
Yeah, that's fine. Oh,
It's important because the 12 to 24, of course, leaves open the possibility of a county CAT or a county jail sentence without any deviation. So I want to make sure she understands clearly what.
Oh, okay. I see what you're saying. Well, okay. Then that maybe helps me understand there is a purpose to that sentence. So I just want you to understand, I'm interpreting that sentence, the sentence in the plea agreement, that any sentence I imposed would have to comply with both a 13-month cap and would have to be within a specified range of 12 to 24 months. So even if the guideline score is 16 to 38, this plea agreement means the sentence must be within a 12 to 24 month range. Still leaves open.
All right, very good.
One other question I had, the principal offense of unlawful imprisonment does have a SORA notice. I don't know if the attempt would do so or if this is a SORA case.
I don't believe it's a sort of case as I review it. There's no minor involved
Yeah,
here.
and there is there was that case that said as applied to non-sexual offenders, it's cruel and unusual punishment. So I would not treat this as a SORA.
I don't think that would be that we're at risk at that.
Okay.
And the people stipulate this is a non-SORA case.
All right. Did you need a minute with her?
No.
Okay. All right. So, Ms. Dockstader, back in August 27th of last year, were you in Presque Isle County?
Yes, Your Honor.
And were you caring for a Victoria Dockstader?
I was.
Okay. And who is that person to you?
It's my mother.
Okay. Is she a vulnerable adult in some
She
way?
is.
In what way?
She's disabled. She cannot walk.
Okay. Were you providing care to her, physical care to her?
Yes, Your Honor.
And did you take away her walker and her telephone?
Yes, Your Honor.
And did that prevent her from, did that restrain her movement?
Did.
And did that prevent her from telling somebody where she was at?
Did.
And you did those things without her consent?
Correct.
Mr. Vogler, do you believe that satisfies the factual basis for both charges? Mr. Wergo?
I do, Your Honor.
And Mr. Vogler, oh, I'm sorry, and Ms. Stockstader, you understand that part of your probation was that you not violate the law?
Yes, sir.
Okay, so do you acknowledge then by your behavior with Victoria that you did also violate your probation?
Yes, sir.
So Agent Leskey, as I'm looking at the warrant, her plea today establishes count 5. And so I'll just dismiss counts 1 through 4 and 6. And count 5 is a non-technical violation. All right, Mr. Vogel, are you aware of any other promises, threats, or inducements?
I'm not.
Mr. Virgo?
None, Your Honor.
And Mr. Vogler, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes.
Mr. Virgo?
The court has.
All right, Ms. Dockstader, I find that your plea in both files is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those crimes. So I hereby accept your pleas. Okay, I'm going to set sentencing in both matters for March 16th at 9:50 a.m.
Your Honor, I would ask at this time, given that her plea has been entered, whether or not the bond restriction with her mother, sister, and whoever other family members be lifted. There was a PPO against her, and I think her sister and her mother both came in and asked the family court to terminate that. It was done last week.
Mr. Virgo?
That is my understanding, Your Honor. The people would not oppose.
So I'll write on this docket call order. Bond remains revoked, but no contact provisions removed. And to the extent that you find that the jail needs something additional beyond that, you can get a copy of that, then you can just submit it.
Thank you, Your
All
Honor.
right, thank you. And have you had a chance to copy Mr. Board? Do we want to do that?
Mr. Gilbert, that was his case.
Ready to go, Your Honor.
Okay, he would take it.
Let's call it, this is an add-on. File 24-93342FH, People v. Matthew Bohr. Counsel, you want to state your appearances, please?
Zachary McLennan for the people.
And James Gilbert acting as the MIDC arraignment attorney for Mr. Bohr.
All right, and Mr. Bohr, it's alleged that you are in violation of your probation in 7 different ways. Some of them overlap. 3 technical violations. It's alleged that on or about January 22nd, you possessed methamphetamine. On or about January 28th, you possessed methamphetamine. And on or about January 28th, you possessed cocaine. It's on technical violations. One of them has a 15-day maximum jail cap. 2 would have a 30-day cap. 3 would have a 45-day cap. It's also alleged that you committed some non-technical violations. Those are as follows. Count 4, that you not violate state law. On or about January 22nd, you possessed methamphetamine. Count 5, not violate state law. On January 22nd, you delivered methamphetamine. Count 6, not violate any state law. On January 28th, you possessed methamphetamine. Count 7, not violate state law. On January 28th, you possessed cocaine. If you were found to be in violation for those non-technical reasons, the court could revoke your probation, and you're on probation for possession of methamphetamine, which carries a maximum penalty of 10 years in prison. Do you understand the maximum penalties, Mr. Ford?
Yeah, sure.
All right, now, you have the right to have a hearing on these allegations, where they would need to be proven by a preponderance of the evidence. The rules of evidence don't apply at that hearing, except as to privilege, but you can present evidence in your own defense, and you could cross-examine any of the evidence that's presented against you. You have the right to a lawyer at that hearing, and if you qualify and request, it looks like you've requested, that then you'd be allowed an attorney at public expense. You have made that request. Do you understand the rights I've outlined for you?
Yes.
All right, and in reviewing it, I find that the defendant is financially unable to retain an attorney, is referred to the local appointing authority for appointment of an attorney. I'll sign that order. And Mr. Gilbert, would that be you?
Yes, I will be assigned to this case. Thank you.
All right, how does Mr. Bohr wish to plead with these charges?
He's going to stand mute and ask to request a hearing, Your Honor.
All right, and I've been made to understand that there's charges pending in Otsego County, at least as to some of these. Is that right?
That's my understanding also.
So we'll enter a plea of not guilty on these, and we can schedule this for probation violation hearing on March 16th at 10:20. Anything further from the defense?
Your Honor, I'm not too sure what the status would be on any possible bond. I would ask that the court, he is under bond in Otsego, so there is that safeguard that he will always appear. And I would ask that the court allow him to post a bond or be let out on a PR bond.
Mr. McClellan?
Your Honor, the people would oppose bond. He's on felony probation for possession of methamphetamine. He was under 7411 status out of the court, and these are very serious allegations involving selling drugs, again, methamphetamine.
And I don't recall whether this case that he's on probation for possession, whether it started as a possession or was a delivery pled down to possession. I don't recall, and it wouldn't really make a huge difference today. Mr. Bohr, you're on probation for felony possession, and then it's alleged that you've been delivering methamphetamine. So I think at this point, until I know more what's going on, I'm happier to have you sit put. So I'll bond.
The bond issue. Not see the record.
And Mr. Someone could care if we got the jury box here. That Ms. Fisher. Yes. Mr. Vogler, let's call people be Brandy Fisher. Like it's 2 files. The docket call, one is a 2021 case, 93178FH, and then 25 case, 93385FH. Counsel, you want to state your first, just beginning with people?
Jeremiah Buffalo, we're on behalf of people.
Your Honor, Michael, I'm representing Brandy Fisher in both files.
Okay, and we're here for a docket call. What's our status here on these?
Your Honor, so we were On January 30th, we received a plea agreement proposal. Would, in order to consummate that, going to require that she plead guilty to a absconding charge. That charge was just filed last week. She's going to be arraigned on it tomorrow. It is anticipated. Well, I can tell you for sure that we will. Fisher will waive preliminary examination at the pretrial on that case in district court, so it will be before you at your first March date. I'm not going to. I can't sit here and promise you that we will take that this deal, but we're seriously.
Let's continue this then to March 16 at 10:40 a.m. If for some reason that charge gets through, very quickly, and you want to move the case along, you could reach out to my assignment clerk and see whether we could just do a Zoom hearing on a special date and time even before the March 16th date. Could be a possibility. Since you made me no promises, I'll make you no promises either, but that's a possibility. Okay. All right. Anything further from the people on that file?
No, Your Honor.
From the defense? Who do we have left? Okay. What's your name, sir? Oh, Mr. Green. That's right. All right. So, Mr. Vogler, let's go ahead and call people who agree. Okay, you know what? Is this
Attorney General.
Yeah, we're gonna have to wait until the Attorney General's in on that, right?
Yeah.
So we'll pass that. Sorry. All right, Mr. Gilbert, is Mr. Pritchett here?
Yes, he is, Your Honor.
This is People v. Joshua Pritchett. It's file 25-93370FH. Counsel, you want to state your appearance?
Zachary McLennan for the people.
And James Gilbert here on behalf of Mr. Pritchett, who's standing to my right.
All right, good morning. We're here for docket call. What's our status here?
Your Honor, this matter has been resolved. The only issue is that there's a financial component to it, and we bumped it out a little bit for my client to get those finances in order. He is working on that, but he doesn't have the amount at this time. So we're hoping with the closing that he has upcoming and potential his tax return that he'll be able to have the full restitution amount at time of plea.
Okay. You want me to put this on my end of March docket then?
That should guarantee that we can have enter at that time.
Any objection, Mr. McClellan?
No objection.
We do have a question.
Yes.
Sorry.
What is worst case if I don't come up with the full amount for any type of reason?
I can't give you that information because I don't even know what the plea agreement is.
Okay.
That's between you and your attorney and the prosecutor.
Okay. Sorry.
Yep. Nope. And you've got the full, the only thing I can tell you is you've got the right to a trial by jury. And if you and the prosecutor don't come up with an agreement, you can have a jury trial on it. The maximum penalty that you face on count one is 20 years in prison.
Yep.
See you then.
Thank you.
Would you continue to
On March 30th, 9:10 a.m.
9:10?
All right, Mr. Johnson, you hear Mr. Dillon?
Yes, sir, Your Honor.
This is case file 25-93363. Will be Cody Gillen. We're here for a docket call. We had it scheduled for trial and then we canceled that when Mr. Gillen retained an attorney. And what's our status here, Mr. Johnson?
Your Honor, an offer has been made to my client. I believe the offer was to plead guilty to operating while intoxicated, dismissals of counts 1 and 2. I believe my client does not wish to avail himself of that offer. We're asking the court for a motion date and a trial date.
Okay. And motion date for, do you know what motion you're intending? Or?
I have them right here, Your Honor. Motion to suppress statement made and motion to suppress the search warrant.
Okay.
Neither would be, they both would apply to the misdemeanor count, so they would not be dispositive of the case, even if the court ruled in our favor.
Okay, gotcha. Do they require, and so motion to suppress, you require an evidentiary hearing then?
Yes, I haven't had an opportunity to speak with the prosecutor about how he wanted to proceed. There's about, the interaction wasn't even 15 minutes. So there's about 10 minutes of video that I would play and the court would make its determination as to whether or not it believes Miranda was required or not. I don't know if the prosecutor wanted to call in the deputy. I wouldn't be subpoenaing the deputy.
Okay. All right, well, what I can do, what I tend to do is any evidentiary hearings I put on 1 p.m. on my motion day docket over here, so that if they do want to bring the officers in and supplement the record, you know, that's permitted.
Yes, sir, yeah.
So we can schedule this for March 16th at 1 p.m. for a continued docket call, and that'll be a motion cutoff, including for evidentiary. And it'll be a plea in motion cutoff then. And why don't we all bring our calendars to that as well, and then we can select a trial date, a firm trial date that day. Bond will be continued. Anything further from the people?
No, Your Honor.
From the defense?
No, Your Honor.
Okay, we'll see you then, Mr. Gill.
Have a good day.
You too. And do I get to see you again in my court tomorrow morning, right? Over in Sheboygan, Mr. Johnson.
Well, I was going to ask to appear via Zoom, Your Honor, but
Oh,
you
yeah.
scheduled. Thank you.
Yeah, that's fine. That's fine. All right, and I do see the Attorney General zooming in. If you want to do Mr. Green's case then. We can have Mr. Green have a All right, good morning. Up next, we've got People v. Joe Green, file 24-93344FH. Counsel, you want to state your appearances, beginning with People?
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Morning.
Your Honor, Mike Vogler representing Joe Green.
All right, and we're here for probation violation hearing on 1 summons and 2 warrants. Mr. Green has been taken into custody on the warrant and arraignment has been held. Do you know what the status is or what we're doing, Mr. Vogler?
Yes, I think we do. So with regard to most of these violations, he's going to admit to, with the exception of the drug test results, in which case he's going to no contest count 1 using methamphetamines. count 2 and 3. Where we can either have a hearing or they can be dismissed, but we're not gonna either no contest or admit to close.
What about the first summons was not making support payments, not attending treatment, terminating employment, and then count 4 was using methamphetamines December 2nd.
That'd be a no contest to that one. The other 3 would be he'll admit.
And the basis for the no contest plea would be he's got other criminal charges pending on those?
Well, I would say that it potentially could create criminal charges against him, or the allegations are breaking the law here.
All right. Ms. Williams, do you consent to the entry of a no contest plea as to the drug test results?
Yes, Your Honor.
All right, Mr. Green, would you please, as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you can put your hand down. Mr. Green, do you understand a no contest plea has the same legal effect as a guilty plea in this court, and meaning that you'd be found responsible for the probation violation and my authority to sentence or punish you for that? Do you understand that?
Yes, Your Honor.
Do you understand that you've got the right to have a hearing on all these violations where they would need to be established by a preponderance of the evidence?
Yes, Your Honor.
Now, the rules of evidence don't apply at that hearing except as to privilege, but you'd be allowed to present evidence in your own defense and cross-examine any of the witnesses presented against you. Do you understand that? You have the right to the assistance of an attorney, and you have Mr. Vogler representing you. Do you understand that?
Yes, Your Honor.
If you are found to be in violation, these consist of more than 4 violations, meaning that I'm not required to, but I could revoke your probation. Do you understand that?
Yes, Your Honor.
And you're on probation to this court for failing to pay child support as a habitual second, which means the maximum penalty that you could face would be up to 6 years in prison. Do you understand that?
Yes, Your Honor.
Has anybody promised you anything in exchange for your pleas here today?
No, Your Honor.
Has anybody threatened you to make you do so?
No, Your Honor.
Is it your own free choice?
Yes, Your Honor.
How do you, well, let's see, we'll take them one at a time. The summons from December 3rd alleges in count 1 that you failed to make payments to your child support case, regular payments, and failed to make regular payments on child support. How do you wish to plead the allegation?
Yes, Your Honor.
So when's the last payment that you made? Okay, you were required to make regular payments as part of this probation, is that right?
Yes, Your Honor.
And did you start out making some regular payments?
I made a lump sum payment.
Okay, and then it's been a while since then?
Yes, Your Honor.
Okay. You acknowledge you could have made better efforts than you did?
I do, Your Honor.
Count 2 alleges that as of December 2nd of last year, you had failed to attend substance abuse treatment. Is that true?
Yes, Your Honor.
And you were referred by your supervising agent?
Yes, Your Honor.
Okay, you just didn't follow through with that?
Correct, Your Honor.
All right, as of count 3, alleges that on or about October 7th, you quit your employment at GFL without notifying or getting permission from your supervising agent. Is that correct?
Yes, Your Honor.
Right. And you knew that as part of your probation, you had to do that?
Yes, Your Honor.
Count 4 alleges that on or about December 2nd, you violated state law by using methamphetamines. You are pleading how to that? Guilty, not guilty, or no contest?
No contest, Your Honor.
All right. And I guess for a factual basis, Mr. Vogler, you don't contest the results of those tests that the probation agent would have?
No.
Okay. All right. Mr. Green, the January 22nd warrant, count 1 alleges that on or about January 26th, you violated state law by using methamphetamines. How do you wish to plead to that? Guilty, not guilty, or no contest?
No contest, Your Honor.
All right. You don't, Mr. Vogler, for that purpose, you're not contesting the results of the drug test that the probation officer would have?
No.
All right. And we'll dismiss counts 2 and 3 in the January 22nd warrant, Agent Lesky?
I believe you're talking about the January 26th warrant?
No, the January, oh yeah, I signed it then, yeah. Yeah, January 26th, it sounds.
Okay. Yeah.
The January 22nd warrant. Mr. Green alleges that on or about January 6th, you failed to report to your probation officer as instructed. Is that true?
Yes, Your Honor.
All right, so you knew you had to report to your agent
Yes, Your Honor.
and you just didn't?
Yes, Your Honor.
All right, Mr. Vogler, are you satisfied with that factual basis?
Yes.
Ms. Williams?
Yes, Your Honor.
Ms. Williams, are you aware of any promises, threats, or inducements for these pleas?
No, Your Honor.
Mr. Vogler, are you? No. All right, Mr. Green, I find that your pleas are knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you have violated your probation, so I do so find. And this is more than 4 technical violations. I think what we'll do is we'll schedule this for a probation violation sentencing, March 16th at 11 a.m. And I'll ask for probation violation report to be prepared by the Department of Corrections. And Ms. Williams, the Attorney General's office may appear for that hearing by Zoom video if you wish, but you're always welcome in here in the courtroom.
Thank you.
Anything further from the people?
Nothing from the people, Your Honor.
Anything further from the defense? Okay, we'll see you then, Mr. Green.
Thank you, Your Honor.
You're all set, Ms. Williams. You have a good day.
Your Honor, I have another case this morning.
Oh, who else do you have this morning?
Mr. Stoneham.
Oh, Mr. Stoneham, yeah, and he's zooming in. There we go. All right. Did I agree to Zoom for you?
Your Honor, I don't know if, Mr. Stoneham was in contact with me yesterday. He did test positive for COVID.
Okay.
So I gave him the number.
Okay.
I do.
All right, it's a recommended delay. I mean, it's. All right, Mr. Stoneham, can you see and hear us? You got to unmute yourself here. Oh, you got to hit a button, a microphone button to unmute yourself so we can talk.
That better?
Yep. All right, so the speaker will be Nancy Stoneham. File 25-969. Mr. Stoneham, what's that noise?
I don't know what you're talking about. There ain't nothing, no noise. It's just my phone's messed up.
Okay, well, we'll give this a try. I understand. Oh, it's what we're hearing our feedback.
Oh. I'm sorry.
All right, I understand that you are under the weather today, your attorney says?
Yes,
Okay. You understand you have the right to be physically present at your sentencing? Do you waive that today?
yes, sir.
Okay, given the recommendations, do you have any objection to a Zoom sentencing, Ms. Williams?
No, I do not, Your Honor.
All right, Mr. Gilbert, have you had a chance to review the pre-sentence report and recommendations with Mr. Stone?
Yes, Mr. Stoneham and I have gone through the PSI. We have no additions or corrections.
Any scoring challenges?
I went through the scoring challenges. I think those are appropriate.
Ms. Williams, any scoring challenges or additions, corrections to the report from the people?
No, Your Honor, I just would like to note that the current, I guess that would be possibly a correction. The current arrears are $13,213.82.
Okay. All right, Mr. Gilbert, anything you want to say on behalf of your client?
Your Honor, Mr. Stoneham is very eager to take advantage of the plea agreement that we've come up with the Attorney General's office. He also already has other money that he wants to submit that he has ready for today. Obviously, he can't do that in person, and we'd ask the court to follow the recommendation. Thank you.
Thank you, Mr. Stoneham. You don't have to say anything today, but you're welcome to. Is there anything you want to tell me or no?
No, sir.
Hey, Ms. Williams, any recommendations from the people?
No, Your Honor, we have reviewed the pre-sentence investigation report, and I would ask that you follow the recommendations contained within today. Thank you.
Thank you. Well, Mr. Stoneham, I'm going to place you on a delay of sentence for up to a year as recommended. During that delay period, you're subject to all the probationary terms listed on pages 2 and 3 in the pre-sentence report. I want to highlight them, highlight the most important of them. You have to maintain employment, pay a crime victims assessment of $130, court costs of $350, state cost of $68. There's a monthly supervision fee to the Department of Corrections, and you must make monthly child support payments to the Presque Isle friend of the court in your pending DM case, the 2018 case. And like I said, you're subject to all the terms in that PSI. I'm just highlighting some of them for you.
Yes, sir.
So if you, under the plea agreement, if you pay as ordered monthly during the delay, and if you reduce the arrears to $8,300 by the time we're back here in a year, then your charge will be reduced to attempt. If you reduce the arrears down to 0, then the charge will be reduced down to a misdemeanor. If you fail to reduce those arrears as agreed upon, by the time we come back for sentencing, you'll be sentenced on the felony fail to pay child support with the guidelines of 2 to 17 months. Do you understand that, sir?
Yes, sir.
All right. And Agent Lesky, are you going to get a hold of him or just?
I will, Your Honor.
Okay. Agent Lesky is going to reach out to you to begin your supervision. And we'll get it on the docket for about 11 months from now to get you back for a sentencing and see how you do. All right. Any questions for me, Mr. Stoneham?
No, sir.
All right. We'll see you then.
Thank you very much, Your Honor.
Thank you very much, Ms. Williams. Is that all you have?
That is, Your Honor. Thank you. Have a good day.
Okay, you too. All right, and we have an arraignment in People v. Jeffrey Cortman with Mr. Pomeranke. Where's Mr. Pomeranke? Are you Mr. Cortman?
Yes, I am.
Okay, we're trying to track down your lawyer here. I'll put you back in the waiting room for a minute.
Hi.
Have you heard from Mr. Pomeranke?
I have not. I'll text him out.
Okay, great. Past that.
Nice to meet you in person.
And I would note a little later on the docket, Skierski v. Shook. I was told by my staff that that's being adjourned until March date when he returns is ill. Civil documents. Did I see Mr. Parks yet? No. The Haramoto case has been, I think, put over to the 11:30. We've got Mr. Vogler with Mr. Zeno.
Yeah, she's downstairs.
Who you need?
Zeno.
Mike's down at the jail, Your Honor. He just walked in.
Okay.
Mr. Clay, here.
Do you want to do Maynard or Earl?
I mean, my client's not here yet. I can do whenever. I'm here.
Let's go off the record. Is anybody here on Scarcity Shut? Did you see this cost? All right, Ms. Koss, I was advised by my staff that we were pushing this to a March date due to an illness of your sister counsel.
That's correct, Your Honor.
Okay. All right, so you're all set then today.
Thank you. I just didn't want to not show, so thank you.
Okay, I appreciate that. You have a good day.
You too. Thank you.
All right, so this will bring us to People v. Jeffrey Portman, file 25-93381FH. Counsel, you want to state your appearances, beginning with People?
Zachary McClendon for the people.
Devin Pomeranke on behalf of Jeffrey Portman.
All right, and we're here for an arraignment, and Mr. Portman is appearing by video from the Pressfield Jail. Mr. Pomeranke is appearing by video from a separate location. Let me know if you need a breakout room to talk. And Mr. Pomeranke, have you reviewed the charging document with your client?
I have.
And do you or he wish its allegations read?
No, Your Honor. We would waive the reading of those in open court.
And how's he plead to those charges?
Your Honor, at this time, we stand mute.
You will enter a plea of not guilty on his behalf. It looks like the top charge is a manufacture of methamphetamine in a school zone with habitual fourth notice. And there's several other counts, 19 counts in total. You know, I have a question though, Mr. McLennan.
Yes.
The habitual fourth notice is for the mandatory 25-year sentence for the violent habitual offender. But can you explain to me whether and why that's applicable?
Your Honor, we will be filing an amended. I don't believe it is.
Okay,
actually.
I don't either. All right. So Mr. Pomeranke, well, I'm sorry, Mr. Courtman, I want to tell you something very important. The habitual offender notice that the prosecutor gave is wrong. You are not subject to a mandatory minimum 25-year sentence.
Okay, Your
We'll
Honor.
file an amended information, and at the next hearing, we'll arraign you on that amended information. All right. I think the court rule gives you a pretty limited window of time to file that amended notice, I think within 14 days or 21 days of this arraignment. So
Yes.
okay, so we'll enter pleas of not guilty as to all those charges. Mr. Pomeranke, is a forensic center referral requested?
It is not.
Estimated length of trial?
I think probably 2.
Okay.
Zach, would you agree?
Yeah, I think we could get it done in 2.
Okay, we can set this for a docket call on March 16th at 11:10 a.m. All right, anything further from the defense, Mr. Pomeranke?
Nothing further, Your Honor.
Anything further from the people?
No, Your Honor.
All right, Mr. Corbin, we'll next see you March 16th at 10 after 11, okay?
Yes, Your Honor.
Have a good day, Mr. Pomeranke.
Thanks, you too, Your Honor.
Mr. Coker's down there with Mr. Zeno. Mr. Williams here yet? Mr. Williams, Jesse Williams, and Harry Milton.
I haven't seen Jesse. Let me see.
All right, we put it on at 11:30 for him. All right, let's call then, Mr. Parks is here. We have Mr. Goddard. Let's call People v. Goddard. File 25-9374FH. Counsel, you want to state your appearances for the record, please?
Jeremiah Buffalo, work on behalf of the people.
Good morning, Your Honor. Christopher Parks on behalf of Mr. Goddard, sits to my right.
Okay, good morning, Mr. Goddard. Last time we were here, we had a little bit of an issue about some stuff you're doing in the courtroom. You've got the absolute right to be present in your courtroom for your sentencing, but you can forfeit that right by your behavior. So I just want to remind you, you and I are engaging in something, and you and your attorney, and that's it. Okay.
I apologize, Your Honor.
No words. Okay. All right, so we're here for a continuation of sentencing, and also we did do a show cause arraignment last time and scheduled this for hearing. I understood, Mr. Wirgo, you wanted to proceed. I'm sorry, is this Mr. Wirgo or Mr.
It is
Wirgo?
not, Your Honor.
That you wanted to proceed with a contempt issue before we go forward with the sentencing, is that right?
Yes, Your Honor.
Okay. All right, and Mr. Parks, are you ready to proceed on that?
Your Honor, I've received no documentation from the prosecutor regarding the contempt. I don't know if they plan on presenting today, but I've not received any videos, any audio, nothing for a contempt hearing, Your Honor. So I don't know what the prosecution intends on presenting. I know we had 30 days for them to get everything together. When I spoke to Mr. Wirgo on Friday to see where we're at with the case, he said he was going to attempt to send me the audio recordings. I never received anything from Mr. Wirgo other than a corrupted file that didn't have anything on it. So I don't know what Mr. Wirgo intends to present today, Your Honor, but I would object as it's not been provided to counsel.
Okay, so you're asking for a continuance?
I'm not asking for a continuance, Your Honor. I just, if they're going to present anything, it should have been provided already. My client's been spending 30 days and has already spent 98 days in jail for this. So
you want me to dismiss the show cause?
I do, Your Honor.
Yeah, I'm not doing that. I'll grant you a continuance if you want. Do you want it?
My client, Your Honor. Your Honor, my client does not want the continuance to proceed today then.
Okay, Mr. Wirgo, you ready to proceed?
Your Honor, Mr. Parks is right. We did discuss this on Friday. In all fairness, he doesn't have this audio. If he doesn't have it, I believe my thought that the last we spoke, I resent it while we were on the phone, but I'll take him at his word that he doesn't have it. In fairness, I don't think that would necessarily be appropriate, Your Honor. I will just use the information and update the factual portion of the sentencing, the PSIR with it. I do not wish to proceed with an evidentiary hearing.
All right, so you're giving Mr. Parks the remedy that I didn't want to give him.
Then I would ask for a continuance, Your Honor, so that he can have this audio. I feel bad sandbagging him if he hasn't seen the evidence. I don't think it's fair.
Well, I mean, here's the thing. What sentence I give Mr. Goddard for this charge that includes a firearm charge and a domestic assault charge. And it's not just a vanilla felon in possession of a firearm. It was a pretty assaultive situation, alleged that he held his wife at gunpoint. What I do to him for sentencing might be affected by what kind of communication he was having with the victim while he was in the jail. So, I mean, I got to have that information to decide on an appropriate sentence. So he said he didn't want a continuance. So you can present the evidence today if you want.
Your Honor, I think that it would be unfair to do so.
Well, I don't care what you think about that. My goodness. Already determined he's not entitled to dismissal. But it's, well, I was certainly going to give him some jail. I mean, honestly, my notes, even before we had that issue, were looking at least 6 months jail. I mean, so he's not really prejudiced by a continuance. I'm continuing this. I'm going to continue this to March 16th at 1:30 in the afternoon. And I want to know what kind of contact he was having with the victim or not before I decide on his sentence. I mean, I suppose if the prosecutor just wants to abandon a contempt prosecution, I can't make you prosecute. So you can tell me at that date and time whether you want to.
I will not be abandoning, Your Honor. I strictly wanted to make sure the defense has that.
All right, that's my job. That's my job. March 16th, 1:30 in the afternoon. See you then. All right, next we've got People v. Antoine Zeno, file 25-93384FH. And we've got Mr. Vogler and Mr. Zeno appearing by video from the Pressfield County Jail.
Yes, sir. Good morning. Happy ground all day.
And I have a plea agreement in front of me here. Who's on this case?
I am, Your Honor.
All right, do we have an amended information?
If I may approach, Your Honor?
Yes.
Yeah, I'll call this.
All right, Mr. Vogler, have you seen this amended information?
No, I have not.
I think it's wrong. Count 4 alleges attempted assault with intent to create bodily harm less than murder or by strangulation. The principal charge is a 10-year felony. This attempted purports that it is still a 10-year felony. Wouldn't it be a reduction to the 5-year?
If I may, Your Honor, it is a weird how it appears, but if the court will look to that second paragraph in count 4 after to say if offense is attempted is punished, and then after that it says felony 5 years. I believe that was supposed to be dropped down to the next paragraph, Your Honor. I do believe that that's just a spacing and formatting issue.
Okay, but then below it, it says felony, 10 years or $5,000. Why should that be anywhere there?
Your Honor, we generated this morning. Our software is
wrong. It's wrong. I can't accept this is a charging document and it's wrong legally. I'm tendering it back to you. File it correctly.
Yes, Your Honor.
I don't care what the software is. I don't care if you have to manually type it. It's got to be legally correct.
Yes, Your Honor.
Mr. Vogler, you content proceeding with the felony information amended to be filed later?
Yes.
All right, Mr. Zeno, would you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay, you can put your hand down. Now, Mr. Zeno, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have a question, ask me. I'm happy to answer it. If you need some time to talk to Mr. Vogler, you just tell us. We're happy to give you that time. Do you understand that, sir?
Yes, sir.
Now I have to advise you the maximum penalty that you could face for these charges. The added count, well, it says added count 3, but it'd be an added count 4. Is that right?
Yes, Your Honor.
Okay. Added count 4, attempted assault by strangulation would be a felony punishable by a maximum of 5 years and or a $5,000 fine. Do you understand that?
Yes, sir.
All right. Are you on probation or parole anywhere?
No, sir.
Were you on bond for any other cases at the time of this incident?
No, sir.
Did you read and understand the rights listed on the advice of rights form?
Yes, sir. Yes, sir.
Okay, and I've got a form here that you signed tail end of last week. Did you sign that form?
Yes, sir.
Do you have any questions for me or your lawyer about any of those rights?
No, sir.
Do you understand if you plead guilty, you won't have a trial and you'll give up all those rights?
Yes, sir.
And is that what you wish to do today?
Yes, I do.
If I accept your plea, you give up any claim that it was caused by any promises beyond the terms of the plea agreement, and you give up any claim that it was caused by any threats. Do you understand that?
Yes, sir.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission. You would do so by filing an application. But the types of issues that you could raise on an appeal after pleading guilty are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, sir.
All right, the plea agreement provides in exchange for your plea of guilty to the attempted assault by strangulation, the remaining charges will be dismissed. There's also a plea agreement for a county cap if the plea is entered by the docket call. So there were some comments that this was contingent on waiver of the prelim, and that sentence agreement had a time deadline of today. Do you understand that, sir?
Yes, sir.
Mr. Vogler, is that a full, fair, and accurate statement of the terms of the agreement?
Yes.
Mr. Wirgo?
It is, Your Honor.
All right, Mr. Zeno. That sentence agreement for the county cap is not binding on me. If I wanted to give you prison, I wouldn't have to be limited by that county cap. But if I did not follow that county cap, you would be allowed to withdraw your plea, not having received what you bargained for. Do you understand that?
Yes, sir.
There is an important exception to that, however. Here's what it is. If you engaged in any misconduct between now and the sentencing, bond violations, violations of court orders, or misbehaviors in the jail, or criminal conduct, by your own misconduct, you would forfeit the right to withdraw the plea, even if I didn't follow that county cap. Do you understand that, Mr. Zeno?
Yes, sir.
Other than this plea agreement, has anybody promised you anything to get you to plead guilty today?
No, sir.
Has anybody threatened you to make you do so?
No, sir.
Is it your own free choice to enter the plea?
Yes, it is.
Knowing all this, how do you wish to plead to the charge and added count 4, attempted assault by strangulation?
Yeah.
And Mr. Vogler, would you assist with the factual basis, please?
I will, Your Honor. So Mr. Zeno, on October 23rd, 2025, were you in the city of Rogers City here in Prescott County?
Yes.
And on that particular day, did you get into an argument with Tanya Trojanowski?
Yes.
And during the course of that argument, did you attempt to stop the argument from continuing by grabbing hold of her?
Yes.
And one of the things that you did when you were grabbing hold of her is you took your hand and you placed it forcefully, and I'm just going to illustrate, into her chin and over her mouth.
Yes.
And did that cause her breath or her ability to breathe to be impeded? Did it impede her ability to breathe?
Well, yeah.
Yes or no?
Yeah.
That's all we have, Your Honor.
Are you satisfied with the factual basis, Mr. Vogler?
I am.
Mr. Wirgo?
Your Honor, I did not catch defendant's answer to that last
Yeah,
question.
Mr. Zeno, did you answer yes to that last question, that it did impede her ability to breathe?
Yes.
Satisfied, Your Honor.
Okay, very good. Mr. Vogler, are you aware of any other promises, threats, or inducements?
I am not.
Mr. Wirgo?
None, Your Honor.
And Mr. Vogler, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes, Your Honor.
Mr. Work?
The court has.
All right, Mr. Zeno, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea. We'll schedule sentencing for March 16th at 10:50 a.m. And you'll have to cooperate with a pre-sentence interview so they can write a report for me with recommendations about what the proper sentence should be. Mr. Vogler, anything further from the defense?
No, Your Honor.
Mr. Virgo, anything further from the people?
No, Your Honor.
All right, Mr. Zeno, we'll see you then, sir. Leaves us just with the Harimoto file. Let's go off the record for a second.
Right, so the complaint,
Well, I don't have an amended information. Has one been filed?
I have one if I may approach you.
Okay. So now I can track better here. You're talking about
so if you look at the amended information,
the
it's,
added count 7. Is that right? The count 7 CSC 4th degree student?
correct. But that's, it really should be, count 7 should be CSC 520E1 little a. That is more factual.
13 to 15.
Correct, because the victim wasn't 16. We would have perhaps different arguments if that was the case.
And was Mr. Harimoto more than 5 years older than?
Correct. That is correct.
All right, Ms. Reed, what's people's position? Is that a typographical error? Are you intending to charge the 1F?
No, when I did the plea paperwork, I intended to charge 1F and I sent it to Mr. Williams. I didn't hear back or any response indicating that they wish to plead to a different subsection.
I just thought it was a typographical error because
Do you have a written plea agreement?
we don't. We just have a CSC 4.
I emailed it to Mr. Williams last week.
Huh?
I emailed a written plea agreement with advisement of rights to Mr. Williams last week.
I need a written plea agreement.
I was gone last week. If that's the case, that's fine. But could we at least, while we're on the record, just clarify, can we just agree that it would be 1A, because that would be more factually accurate, because the victim at no time would have been 16 years of age.
The penalty the same?
It's a, yes.
Exactly the same.
Penalty's the same. It's,
I don't have any objection. I can email the court a written plea agreement to print. The court wanted me to do it that way.
What we're going to do is I'm going to calmly go off the record and in a minute and remind you both that the reason we did this in person was because I wanted the paperwork in order. I'm going to take a recess. We're going to get the paperwork in order. And I'll come back on the bench when.
thank you.
In the amended information, looks like it still is the 1F. We're going to later file a 1A or what's
So I just handed you one with our initials and signature on it.
Yeah, the plea agreement says 1A, but
Okay.
the charging document is a 1F.
Can we stipulate then on the record that it's what we assigned to is what it should be, and then they can amend later?
Yeah. So can you file an amended one later?
Yes, Your Honor, I can.
All right, so I'm gonna not give to the clerk either of those amendeds, so it won't be a second amended, just file an amended information.
1A.
1A. All right, if you can do that within 7 days.
I can do it this afternoon. Shall I email it?
Email it to the clerk's office and to Mr. Williams, and then if Mr. Williams has any objection to it, we can schedule at least a phone conference.
That's fine, Your Honor. 1A, there's no objection for the record.
All right, Mr. Harimoto, would you please stand and raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can be seated. Are you Alex Yoshio Harimoto?
Yes, I am, Your Honor.
All right, Mr. Harimoto, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen very carefully. If you have any questions of me, go ahead and ask. I'm happy to answer your questions. If you need more time to talk to Mr. Williams, just let me know. We're happy to give you that time. Do you understand that?
I do, Your Honor.
Now, I have to advise you the maximum penalty that you face under this plea agreement. There will be an amended information later that will add a count 7, criminal sexual conduct in the 4th degree under subsection 1A of that statute. And that is a high court misdemeanor punishable by a maximum of 2 years in prison and or a $500 fine. And there's mandatory HIV and STD testing. It's also subjects you to registration under the Michigan Sex Offender Registration Act. Do you understand the maximum penalty, sir?
I do, Your Honor.
Are you on probation or parole anywhere right now?
No.
Okay, were you on bond for any other cases at the time of this incident?
No.
All right. I'm going to go ahead and advise of the trial rates because that advice form is from June of 2019 and it's outdated. There's a May of 2025 one. It's operable. Mr. Harimoto, do you understand if you plead guilty, you won't have a trial of any kind and you'll be giving up the rights that you would have had? I want to remind you of the most important of those trial rights. You would have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. Do you understand that?
I do.
And at that trial, you would have the right to have the witnesses against you appear, and you'd have the right to question. You'd have the right to present any witnesses in your own defense and have me order those folks to show up. Do you understand those rights?
I do.
Also, at your own trial, you'd have the right to either testify in your own defense or to remain silent and not have your silence used against you in any way. Do you understand those rights?
I do.
Do you have any questions for me or Mr. Williams about any of those rights?
No, this one.
Do you wish to give up those rights and enter a plea here today under this agreement?
I do.
If I accept your plea, you give up any claim that it was caused by threats or by any other promises beyond those contained in the plea agreement. Do you understand that?
Yes.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal later, you'd have to seek permission. So this is if you go ahead if you have a question for your lawyer.
Okay, you repeat that again, please?
Yes. So by pleading guilty, you lose the right to appeal. If you went to a trial and were convicted, you'd have an automatic right of appeal. And you could raise any issue you wanted, and the Court of Appeals would have to give you their answer to those issues.
Okay.
By pleading guilty, you have to seek permission to appeal. You do so by filing an application for leave to appeal. The Court of Appeals doesn't have to take your case at all. And even if they do, the types of issues you can raise on appeal after entering a plea of guilty are very, very limited. They're much more limited than the kinds of issues you could raise if you were convicted after a trial. Do you understand that principle?
I do, Your Honor.
The plea agreement provides that in exchange for your plea of guilty to the added count 7 CSC in the 4th degree, the prosecutor will dismiss the remaining charges. There's says the prosecutor will recommend a period of incarceration in conjunction with a term of parole / probation supervision, which basically means there's no guarantee of what the sentence is going to be. That's basically everything that's on the table for that charge. Do you understand that?
I do, Your Honor.
All right. And there's been no agreement with this court as to what your sentence is going to be. All right.
Yes, Your Honor.
All right. Mr. Williams said a full, fair, and accurate statement in terms of the agreement.
Yes, it is, Your Honor.
Ms. Reed.
Yes, Your Honor.
All right, Mr. Harimoto, other than the plea agreement, has anybody promised you anything in exchange for your plea?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
Is it your own free choice to enter that plea?
It is, Your Honor.
Knowing all that, how do you wish to plead to the charge of what will be added count 7, criminal sexual conduct in the 4th degree, person between 13 and 15 years of age?
Wish to plead guilty, Your Honor.
Mr. Williams, would you please assist with the factual basis?
So, Mr. Harimoto, without mentioning the person's name, did you have a mutual but sexual relationship with a person here in Seal County?
Yes.
Was that here in Ryder City?
Yes.
Was that person at least 13 years old and less than 6? And during that relationship, did you, for a sexual purpose, have contact with that person?
Yeah.
By touching that person, being sexually aroused by that person, finding gratification in touching that person's sexual areas, like such as their breasts or buttocks area?
Yes.
It's here in Presque Isle County, correct?
Yes.
Your Honor, I believe that's effective.
And at the time, were you more than 5 years older than the person?
I was, Your Honor.
Ms. Reed, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Williams, are you aware of any other promises, threats, or inducements?
No, the signed plea agreement has the correct statutory 1A, so thank you.
Ms. Reed, are you aware of any other promises, threats, or inducements?
I'm not, Your Honor.
And Mr. Williams, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes, it has, Your Honor.
People agree, Your Honor.
All right. All right, well, Mr. Harimoto, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea. We'll schedule sentencing for March 16th at 11:30 a.m. Here in the courtroom. You'll have to cooperate with an interview and the preparation of a pre-sentence report. And I guess a sexual assault plea having been entered, I'd like to hear from both parties about the issue of continuation of bond or remand. Ms. Reed.
Your Honor, this plea agreement was made at the request of the victim in this case because she really wanted to minimize the circumstances or the consequences for the defendant. My understanding is he currently resides out of state. As far as I know, there's been no, he's made all his court dates and appearances. I don't anticipate that he will not appear for sentencing. I don't honestly have any reason to recommend that bond be revoked at this particular time.
All right, Mr. Williams.
Yes, Your Honor. He does live in state, but besides downstate. He has put himself into treatment counseling. He's working with the Burgess Group, who works exclusively with the youth sex offender program in Grand Rapids. I do have quite a bit of experience with that program. He's doing very well, and he has not had any contact or bond pleading to something that does have a presumptive no jail sanction. So I would ask the court to continue bond. I do want a final update for the court
from his doctor that's doing the treatment down in Grand Rapids for the court considered sentencing. And he's actually participating in the program that the kids who get sentenced to youth sex offender treatment assignment in Kent County. So he's doing what he would do and all these other youths do. And that program so far has 0 recidivism rate. So for all those reasons, I would ask the court to continue his bond.
Well, plea having been entered, Mr. Haramoto is no longer cloaked with the presumption of innocence. Bond is entirely discretionary with the court. There are statutes that discourage it in these kinds of cases, saying that I can't even continue on bond unless there's clear and convincing evidence that he's not a danger to other persons. Here, he was 24 years old and engaged in a sexual relationship with a 15-year-old. I understand there's some dispute about the nature of the school's involvement in that. Not involvement is the wrong word, but I guess Mr. Haramoto's involvement at the school as a non-student volunteer, and that's why the particular subsection the plea was entered into appears to be important to the defense. I don't discount that. But even laying that aside, a 24-year-old engaging in a sexual relationship with a 15-year-old, and this plea agreement is a significant reduction that I had expressed to counsel off the record at a chambers conference that I tend to give a lot of incarceration in these when it's reduced from a first to a fourth. So at this point, I'm going to cancel Mr. Haramoto's bond. He's remanded to the custody of the Prescott County Sheriff until further.
All right. May I just address the court on that just briefly? I know
So you made an argument, I ruled against you, and you want to press the argument further. That's generally not how things work. I heard from you both, and I made my ruling.
Okay.
We'll be in recess.
Well, I'm going to go ahead and call it right here, ladies and gentlemen. It's been fun. It's really hard. 29 missing, 29 unavailable videos with this Judge Gauthier. I had a bunch of videos that would have kept me in content for a long time. So him and Judge McNally probably be coming off that list pretty soon. So if you see judges show up twice in a month, it's just the way that it ends up being scheduled, I guess. It happens, that's the way it happens. Again, I want to thank everybody who watches afterwards. Your support means a lot to me. And if you're not a subscriber to this channel and you like this content, please do me a big, huge favor and subscribe to this channel and help this channel grow. I really appreciate it. I know I set a 500 subscriber goal before the end of this year. I'd like to keep that. That would let me partially monetize and also help pay the bills, the internet bill, once I got enough money generated from it. If you want to give too, you can give to my Cash App too. If you want to really help support this channel in more than one way, I mean, you don't have to send money donations, but if you can send a money donation, you can send it to my Cash App. The Cash App is listed on the homepage. Why did the captions disappear? That doesn't make sense. All the technical difficulties of running a live stream. Yeah, I mean, there's two ways that you can support our channel. You can support our channel by watching. You can support our channel by subscribing and helping the channel grow. or if you want to send a couple dollars, the Cash App link is in the main homepage of the channel. So I'm going to go ahead and call this one, ladies and gentlemen. I will see you guys tomorrow on the next one. Ta-ta and ciao ciao. And have a wonderful evening.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right when I'm falling apart. You put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright when I'm falling apart. You put me back together. Daniel, you make it better. Daniel, make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, now I'm standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's